Welcome to Hurt at Work, a Kentucky workers' comp podcast. Today, Louisville workers' compensation attorney Scott Scheynost is going to provide helpful information, tips, and advice for injured workers and their families. Scott's goal is to help you to maximize the benefits you receive. If working's got you hurting, sit back and listen to Scott address topics that matter to you. Friends, welcome back to the Hurt at Work podcast. Scott Scheynost, welcome to the studio, guy.
Morning, Jim. How are you doing?
Buddy, I'm doing great. Glad to have you in the studio. And today we're going to talk about something that comes up in workers' comp claims fairly often. These are called third-party claims, and that often results in some kind of accident and injury. And it makes the case a little bit more interesting, would you say?
Yes, it does. A third-party claim generally involves a workers' compensation injury that was caused by somebody that is not a fellow worker. If, for instance, you're in a car and you're delivering stuff for your company and you get rear-ended by someone, well, that's a workers' comp claim because you're in the company vehicle on company time. But in addition to the workers' comp claim, you also have a third-party claim against the person that hit you. Most commonly, I see that in motor vehicle accidents because usually when you're driving a car and you're hit by somebody, if you're driving a car for your employer and you're hit by somebody, it's not usually the same employer. But it also applies to other things, typically maybe on a work site, a construction work site.
In a factory even. In
a factory too. On a construction work site, let's say that you're a roofer and the electrician moves the ladder that you thought was there and you fall down. Well, that might be a lawsuit against the electrical company. And you're in your factory and you're on the line, you're repairing some stuff, and the delivery man comes in and drops off a load that he wasn't supposed to drop off onto your foot. Well, that's a third-party action against the delivery company. So the third party happens a lot in workers' compensation claims, and it's important to remember that you can not only have a workers' comp claim, but also a third-party claim. And there's an interplay between the two of them. For instance, the workers' comp claim, you still get all the same benefits that you would get in a regular workers' compensation claim. You get your medical treatment. You get money for being off work. You get money if you have a permanent problem. So you've got the regular workers' compensation claim. But you also have the claim against the third party, and that can be usually a little bit more lucrative than the workers' compensation claim itself. And the main reason is that the third party claim will allow you to recover pain and suffering.
So let me back up a little bit. So they call it a third-party claim because you've got you as the first party, you've got your employer as the second party,
correct.
And you've got this third individual or this third company involved.
That's right.
So that's why we're calling it a third party.
That's why it's third party. So there's three people involved instead of just the 1-2 from the employer relationship.
And so in that case, you've actually got two separate cases going forward, or two separate claims going forward at the same time. But again, as you said, in the third-party side of it, which is not the actual workers' comp side, you have an option of pain and suffering as part of that claim.
Well, and it can even be more complicated than that. Sometimes you even have a Social Security claim on top of all this stuff.
Right, that's right.
And some people have their own private disability or health insurance that sometimes gets involved in it too. So it can get real interesting with all the interplay. And the main thing here is to try to get the injured person all the damages they're entitled to receive. And we try to sit down and look at all the possible scenarios and who might be responsible to see where we can get those recoveries from. From the injured party standpoint, number one, they need to realize there's a possible third-party claim out there. You just don't want to forget about it. If you're hurt at work and somebody that you're not working with caused the injury, then you need to look at a third-party claim. You can't sue your employer. You can only recover workers' compensation benefits from them. You can't sue a fellow employee. You're limited to just workers' compensation benefits from them too. But if somebody else caused it, then you might be able to file a lawsuit to recover those additional damages.
And that's the interesting thing, from the attorney standpoint, you're going to delve into that. You're going to explore that. Well, tell me about the injury. How did it happen? Where did it happen? Who was involved? And you're going to look for those flags that say, hey, wait a minute, this may be something more than just a run-of-the-mill workers' comp claim.
That's right. And some of the important things to remember is that there's a different statute of limitations.
And what actually is a statute of limitations?
Statute of limitations is a law that prevents you from filing a lawsuit or a claim after a certain time. In a workers' compensation claim, it's either 2 years from the date of the injury for a traumatic injury or 2 years from the last date that you received money from your workers' compensation insurance carrier in the form of temporary total disability benefits for being off work. So your workers' compensation claim, if you're off work for a year and a half recovering from a couple of surgeries, you may not have a statute of limitation that runs for 3 or 4 years. Now, in a third-party claim, typically in Kentucky, there's a 1-year statute of limitations.
And that's standard with any sort of a motor vehicle accident. So I'm out on Dixie Highway. Yeah. I'm in a fender bender. I've basically got roughly a year to file that claim.
Well, motor vehicle accidents have a 2-year statute of limitations.
Okay.
Yeah,
okay.
And that can be extended. But if you're at work and your foot gets run over by somebody driving a forklift that didn't know what they were doing for the delivery company, you've only got 1 year to do something. So
Interesting.
You could still be off on workers' compensation benefits, going through surgeries, trying to recover from the injury, and your statute against that person that caused it may have expired. The bottom line is really to talk to somebody that knows a little bit about this, an attorney that can tell you how long you've got to do this. But it's an interesting interplay because I've seen people come in a day or so before the statute ran on the third-party claim. They had literally a year or two left on the workers' comp claim, didn't know about it. We've had to jump through some hoops to get stuff filed real fast.
And so really, if the statute of limitation is just a window during which an actual claim has to be filed.
Right.
Now, if I go a day or a few hours beyond that window, typically that part of the claim is over, right? I've missed my opportunity.
Right, unless there's some good reason like you're under disability or...
Dog ate my homework.
Yeah. But for the most part, you almost have to assume it's going to run at the point of time.
Right. So what makes this complicated is you've got 2 claims, but you've also got 2 time clocks. And again, as an individual who's already dealing with an injury and loss of work and things like that, that's a lot on your shoulders. You need to get an attorney involved.
Yeah, it is. And your workers' compensation claim has a life of its own, and you might have that going with a workers' comp adjuster who's paying for all the treatment and paying for you to be off work, and you think everything's okay. But, you've got this other claim going on, and they're hoping you forget about it. If you don't file it within 1 year, if it's not a motor vehicle accident, then it's over with, and they're happy. And you've got to do other things to get that case going, too. You've got to file a lawsuit sometimes or try to get it settled before the 1-year statute. If it's a motor vehicle accident, again, you've got the motor vehicle statute that gives you 2 years from the date of the injury or 2 years from what's called the last PIP payment. So if it's a motor vehicle accident, typically you have a little bit longer than a year to file. But the bottom line is, most people don't know what the statute of limitations is, and you need to talk to somebody that can sort through all these things and figure it out.
Right, that makes a lot of sense. And you, coming back to some of the examples, you talked about if you're a roofer and the electrician moved the ladder, that can happen. Maybe you get rear-ended while you're delivering something for the company.
Yeah.
It can also be maybe you're working in the factory and you've unplugged something. You're in a lockout tagout. Somebody just plugs it back in, doesn't know why it's unplugged, plugs it back in, and suddenly you've got a significant injury. On that piece of equipment.
Yeah, I've
all
actually,
that stuff can happen.
Yeah, I've actually seen that happen before. If you thought it was locked out, tagged out, and you get hurt because it wasn't. If a fellow employee did that, then you're limited to workers' comp. But
if another sub or another party, again a third party,
the maintenance people for this company that come in and work on this machine plugged it in, didn't tell you, and you turned it on. Well, you probably have a pretty good claim against them too. So.
Yeah. And this can be maybe they're doing some work on the factory floor, so they've kind of railed it off, or didn't mark it properly, and somebody falls in. Right. I mean,
I've seen that claim before too with people coming in. Yeah, there's and I think I saw one time where somebody was cleaning for asbestos, and the company had not marked it off properly, and actually got a very, very bad injury almost from that exact same scenario.
And I think the reason I bring it up is because when it comes to third-party claims, there's a lot of different ways it can actually happen. And I think a lot of times when we're injured on the job, we kind of think, well, this is just comp.
Yeah.
But no, there's a lot more to it.
Yeah, and if you get hurt in a workers' comp injury, and if you got hurt in a motor vehicle accident, normally that's going to be a third-party claim unless you get hit by another driver from the same company. If you're at work and you're injured by a machine, that might be a third-party claim, too, against the machine manufacturer. If the machine's defective, sometimes they don't have the right safety guards. Sometimes they don't have the right lockout, tagout procedures that can be used to prevent somebody from getting injured.
Or the company who installed it basically left something off, a guard or a screen or something like that, right?
Yeah, or it's designed improperly. I've seen those kind of cases before, too. And then the one that also happens a lot, it seems like at a construction site. You're working for a contractor, maybe it's, like I said, the roofer, and then another contractor comes by and they're doing some stuff that you didn't know about or done something improperly that causes you to be injured. You may have a claim against that other contractor. And that gets a little bit complicated because In a contracting situation, if you're a subcontractor, a lot of times you can't go against the general contractor that hired you because they're also liable for your workers' comp benefits. So the law essentially holds that if someone has to pay you workers' comp benefits, if your employer didn't get insurance, but you can get benefits from the general contractor, then you also cannot sue them in in a third-party lawsuit. You're limited to just workers' comp. So you almost have to have another subcontractor that's involved that's not in the same kind of business as you. That causes the injury and that would not be responsible for your workers' compensation payments.
But on a large job site, that's not uncommon to have multiple contractors, multiple subs in there.
No, there's a lot of moving parts. Anybody that's been there can say.
Big time.
Yeah. And on top of all this stuff, in workplace situations, you may have an OSHA violation that caused your injury, and in workers' compensation, that gets you additional benefits in workers' comp. That may also get you additional benefits in the third-party claim, too, because that could bring in punitive damages, negligence per se, which makes your case a little bit easier. There's a lot of aspects of that, too. So if you've been hurt at work and somebody else other than a federal employee or your boss caused it, you need to check out this potential third-party claim. The statutes are different. Generally, the money is better than it is in workers' comp because you can recover pain and suffering. There's a lot of interplay among all the different possible places you can get money from. As you go through these cases, you prove a lot of the same things, but at the end of it, there's subrogation claims and set-offs and stuff like that. And I don't know if we want to spend 2 or 3 hours discussing all that. But sometimes the workers' comp carrier gets paid back for what they paid you if a third party is responsible through subrogation. If you're getting Social Security and you're getting workers' comp, there might be some money offset. Sometimes you're also eligible for PIP benefits, even though you got hurt at work. And the PIP carrier sometimes might have a subrogation claim. It all gets to be very technical. But bottom line is that not only do you have a claim, but you've also got to deal with everybody at the end of it to kind of clean things up. There's a lot of things that affect your recovery. I don't see how somebody that's not experienced in the law could really do all that stuff. You need somebody that really, really knows what they're doing to be able to handle all those potential claims and make sure that you get what you're entitled to receive and don't have to deal with any loose ends at the end of it.
Well, and a lot of people think, the injury wasn't that bad. The company seems to be taking care of me. I think I'll be okay. But you don't know what the long-term ramifications of that are going to be. And sometimes there's ongoing medical treatment. And there are a lot of things that, was it 2018 when the workers' comp laws were updated? I mean, there are issues dealing with lifetime benefits and having to renew those. And there's a lot of different things going on in the area of workers' comp that the average worker probably isn't aware of, and why would they be?
Right. Well, yeah, and also what's really interesting is sometimes you may not have a very viable workers' comp claim because essentially once you get your medical treatment and you're okay, if you don't have any permanent problems, then your workers' comp claim's over. But you could have a third-party claim because even though your workers' comp claim's over, you don't have a permanent injury, you had a lot of pain and suffering from having to deal with the accident for the 9 months until you're okay. And even though the workers' comp claim has no value anymore at all, you're back to work, you don't have any permanent injuries, there's no future medical treatment, the third-party claim resulted in a lot of pain and suffering that you have a good chance to get some money for. So it's really interesting how this stuff can interplay. Something might be worth a whole lot in a third-party claim and may not be worth anything in the workers' comp claim. Sometimes it's the other way around. Like I said before, you may have some other things involved in this too. You could have a Social Security disability claim out of all this stuff. You may have short-term, long-term disability that's also impacted by this. There's just a lot of things that can happen. But the bottom line is if you were hurt by somebody other than your employer at work, you need to get it checked out. The motor vehicle accident situation seems to be most common because usually if you're in a motor vehicle accident, it's somebody else's fault. I do have a couple of cases where people were injured by fellow employees in motor vehicle accidents. But if you're in a motor vehicle accident, you've got workers' compensation benefits that are available for you. Those are what are called primary benefits. Workers' comp is supposed to take care of all your medical treatment. It's supposed to pay you money for being off work. But if it's in a car accident, in addition to the workers' comp benefits, you may have PIP, personal injury protection, available, and that pays secondary. So if you get in a dispute with a workers' comp carrier about whether or not a doctor bill should be paid and workers' comp won't pay it, well, PIP might pay it. If you get in a dispute with a workers' comp carrier about whether or not you should be off work and they say that you shouldn't be, but a doctor says you should be, then, well, the PIP may pay that because they're secondary.
In the PIP, to kind of define that, that's personal injury protection, and that's basically anybody that's out there driving. It follows the automobile. So if that automobile has coverage,
correct,
then not only the driver but the passengers.
Correct. If it has coverage, right, and if it doesn't have coverage, a lot of times the Kentucky Assigned Claims Plan, PIP is more or less a Kentucky. Well, there's other states that have no fault, but in Kentucky we have No Fault Motor Vehicle Accident Act that allows people to receive a certain amount of money in a motor vehicle accident, no matter whose fault it is. That's why they call it no fault. So it's secondary to workers' comp, and I usually deal with situations where there's some kind of argument with a workers' comp carrier. So it's a nice little extra cushion to help somebody if they were injured at work. That's available for them. There's also a lot of times, even if you don't have insurance, a lot of big companies don't carry insurance on their cars because they don't want to pay PIP. They can waive that.
Wow.
Sometimes, depending on the situation, there might be a government agency called the Kentucky Assigned Claims Plan that might be available to pay it. Sometimes people carry their own added PIP that might follow them around in certain situations.
Or if you're using your own car. You're using your own car and you're driving. I mean, I was a sales rep for years, and I had my own car. And yes, I was doing company business, but I've still got a property damage claim. I've got all these other things, that I've got to worry about.
Yeah, generally your own personal insurance is going to be at least secondary to the workers' compensation. And there's other forms of insurance you have out there too, uninsured, underinsured motorist coverage.
Yep.
That might be available to pay pain and suffering. If the person hits you doesn't have any insurance, you may actually have some insurance on your own motor vehicle that might come into play and help you out in this situation. But the bottom line is there might be other things other than workers' comp out there. And the other things have different statutes limitations. They have different things you have to do to get them. They have different interplay with workers' comp, PIP, no fault, underinsured, uninsured, liability, Social Security, disability. I don't want to make it too complicated. But, you've got to sometimes, especially in a motor vehicle accident, a whole lot of different things that need to be looked at to determine if you might be able to recover money. Obviously, if you've got a small injury, then a lot of these things may not come into play, especially a small injury that resolves in time. You may just have a small workers' comp claim where they pay you to see a doctor or a chiropractor for a while, then that's over with. Then you get a pain and suffering claim against the person that caused the injury, and that may be it. And generally, the bigger the case or the bigger your injuries, the more these other things are going to come into play. If you've got injuries that would result in somebody not having enough insurance to pay them, you may have underinsured motorist coverage. You may have Social Security, disability if you're not able to work. There's all kinds of different things that come into play, and you just need to sit down and talk to somebody. And the more serious the injury, the more important all this becomes, to make sure that you've gotten recovery for you and your family that might be out there, and you're not missing something.
Right. And Scott, there's a lot of complications to these kind of issues, these type of accidents. But you've been doing this for a while. You've seen a lot of this. I mean, this is your 25th year in private practice. Is that right?
Actually, yeah, more than 25.
Yeah.
But we've been doing this in different scenarios for more than 30 years. And about 26, 27 years in private practice. And we've seen a lot of different scenarios. You've got a lot of insurance available sometimes. And then there's the interplay with all the insurance companies, like I was saying, who's primary, who's secondary, and then you've also got what's called subrogation claims later on. Even if you've got Medicare's got a subrogation claim, and you've got to deal with them and figure out how much you have to pay with them.
Well, that surprises a lot of people. They see these big awards, that they hit the headlines and things like that. But if the hospital has a medical bill, I mean, they can come back and file against that, right? They have a right to be repaid.
They have what's called a subrogation right to be repaid if they've incurred some losses because of this injury, mainly through the insurance companies that pay the hospital bills. But yeah, they have a right to be repaid, and you've got to deal with them or they'll come after you.
Which is horrible because I just went through an accident. It's not my fault. I've got catastrophic injuries, and now I've got the hospital coming after me for what I thought was my money free and clear. I'm going to Disney World.
Yeah, well, my experience is most people don't have enough insurance available to pay for their damages if they have a big injury. And in general, what you're doing is you got a lot of people fighting over a small pie, and it's being cut up several different ways. And, of course, you want to try to get it cut up in a way where you get the biggest piece. But you've got to deal with all these people, and if you don't deal with them, especially the government, and you're going to have to deal with them later on. They're going to sue you. They're going to try to recover the money from you. The government won't pay for your medical treatment. There's a lot of different things that can happen, and you just want to make sure it's all tidied up and neatly done, and you don't have to worry about all those things at the end of it.
And that's part of the value that you as an attorney, especially an attorney who's had such a career in this area of law, your knowledge, your background, your experience, I mean, that's what people are relying on.
Yeah, not only do we try to help the person with the claim itself against the workers' comp carrier, or if you've got a third party against that third party, but at the end of it, a lot of times what we'll do is we'll try to negotiate a better deal for these subrogation claims too. And, my experience has been most people, insurance carriers, medical providers, don't always settle for 100%. They'll usually settle for less than that for what the bill is. So sometimes we can give a fair amount of value back to our client by settling, a $50,000 hospital lien for maybe $35,000. We can't guarantee that's going to happen. Sometimes we can set them for a lot less. It just depends. And, we try to get the best resolution we can.
But the fact is, you're negotiating these types of claims every day. I mean, this is what you built a career doing. And you probably understand, well, this insurance company is more likely to go this way or that way. And we've had a similar claim. So you understand kind of what the law of averages are.
Right.
And you understand the value of that individual claim versus an individual walking into that arena and say, hey, I think I'm going to handle this myself.
Yeah.
Not that they can't. But, wow, there's a lot on the table.
Well, it's just a little bit easier, I think, for us to do because we were actually doing this yesterday. But, you want to try to get the best deal you can for your client. And one of the ways you can do that is not only handling the original lawsuit, original workers' compensation claim, third-party claim, but also trying to resolve the liens. We call them liens, subrogation claims, later on in as good a manner as you can. But the bottom line is to try to get, as much damages recovered as possible for the client. Try to figure out where, the damages might be recovered from what parties. Try to work out the best deal, subrogation, reimbursement amounts that we can with those people that also have their hand out wanting to be repaid.
Right.
And the bottom line is just try to help our folks out as best we can.
You use the legal term pain and suffering, and that kind of has taken a hard knock over the years of, well, pain and suffering, what is that really about? And some people make a joke about pain and suffering, but those are legitimate claims in a lot of the kind of cases that you handle. What really is pain and suffering?
Pain and suffering is a trauma that you go through because of an accident, motor vehicle accident, whatever the situation is. The problem with pain and suffering is it's very hard to measure. People can see a broken bone on an X-ray. They can see blood dripping off of somebody's arm. They can see a knot on their head. But you can be hurt from an injury that doesn't show on the outside. You could have a crushed vertebrae in your back. And, you could be standing next to somebody and they think that you're perfectly okay, and that crushed vertebrae is pressing on all your spinal columns, and you may not be able to walk because of it. And it just doesn't show up, on a photograph from outside.
You can't take a photo of pain.
Yeah, you can't take a photo of pain. And what you have to do is you have to demonstrate that to the workers' comp carrier or the third party. Has this person received pain medicine from a doctor who thinks they, suffered an injury that should be medicated? Has this person, have they got different symptoms that show they have pain? Reduced gait, change of range of motion, tremors, spasms, things like that. Typically, the amount of medical treatment you've gone through is a good indication of the pain. If you've had to go to the doctor and get 3 or 4 injections for pain, that's an indication that you've got some. If you've had to get pain medicine, that's an indication that you've got some. If you do have the visible injury that resulted in a scar, surgery, something like that, well, that's an indication that you've had pain too. It's hard to measure pain, but we can try to prove that. If you've never had a problem before and all of a sudden you can't work and you're 65 years old, that's also an indication that something's going on. So pain is hard to measure. That's why it takes a hard knock. And my experience has been that most people that knock on pain don't believe it until they've actually gone through a painful situation. And I've had several friends that say, this pain and suffering is just junk. I don't believe in it. And then they have a car accident where they can't work for 9 months, and they've had an injury that doesn't really result in an outward demonstration of the injury, but I can tell that kind of problem is going to hurt them, and they talk about it then. When they live through it, they understand what they're going through.
Right.
But it's hard for people to understand because it's not visible. It's hard for people to believe because it's not measurable. But it can be demonstrated, and it's a legitimate problem. And I think somebody that's gone through an accident and understands, what they go through will also understand about pain. But for other folks that might be on a jury, you've got to demonstrate it to them.
Well, it's easy to sit up at the stands of the game and heckle the pitcher until you're standing on the mound throwing the ball yourself,
Exactly. There's a lot of things that result in pain. There's the obvious trauma. There's the treatment for the injury. If you have a surgery and you got to get a scalpel go through your skin and you got to go through physical therapy after that, if that's not pain, that's suffering.
Right. And that's the other side of it, suffering. I mean, if I suddenly I've got a scar on my face and I'm somewhat disfigured or on my arm or something like that, I've got to live with that.
Right.
And the treatment's over, but I still have to see that every day, and I have to be aware that everybody else is seeing the same thing.
And some of this stuff is not transient. Some of this is permanent. And, if you're a 22-year-old kid and you've got to live with a scar on your face for the rest of your life, well, that's a lot more pain and suffering than it is for somebody that might be 65 that's no longer working, that has an injury maybe to the back of their arm.
Yeah, and it's hard, as you said earlier, it's hard to put a price or a cost on that, but there have been so many cases previously litigated and settled, so we have a kind of a track record, and there's a way
different ways to measure it.
Yeah.
The insurance companies have a computer program called Colossus that measures this, and it looks at the medical treatment and essentially the extent of medical treatment that they use to formulate their offers. But it's a computer program. It's not perfect, and there's other things that come into play, and everybody's situation is different.
Right.
The computer program's not perfect, or we wouldn't have lawsuits. You would just get the money the computer says you get. So everybody's situation is different. Everybody really needs to sit down and talk to somebody if they have it. The bigger the claim, obviously, the more important this is. But the pain and suffering is just hard to measure.
But it's a real component of many of these claims.
Yeah,
at least on the third-party side. Work comp, it doesn't come into play.
Well, it actually does come into play. Yeah. There's a lot of things that result in pain because it can affect your ability to work, it can affect your ability to move, affect your ability to concentrate, other things like that. So actually pain can be a very big element in workers' compensation. Again, it's hard to measure in workers' comp. The problem with pain in workers' compensation is that the way we give out permanent money in workers' comp is through impairment ratings generally.
Yeah.
And the book that tells doctors how to give impairment ratings only gives 3%, the most it will give for pain. So somebody could have a very, very traumatic injury that results in a lot of pain, and they would only get 3% for that pain. Sometimes there are some ways to get around that. Maybe it's reduce their range of motion. Maybe they have a change in their gait, the way they walk. There's other things that can be looked at to try to increase that impairment rating, but pain is actually a pretty big factor in the workers' comp claim too.
Right. Interesting. Well, Scott, some closing thoughts here on these third-party accidents. One, it's just, I guess the main theme of this is it's complicated, and you really need to have somebody with the experience who understands how to look at the whole picture, to really manage that case for you.
Right. I think the number one thing to think of is, first of all, if you get hurt at work and somebody else was responsible, you may have a third-party claim. And then from that point on, you probably need to talk to somebody to make sure that you preserve your statute of limitations, that you're getting all the damages you might be able to get. And then also, even if you get money to deal with the subrogation claims afterwards, to make sure you retain all the money that you can. And it is complicated, and we could probably talk. I could talk for another 3 or 4 days about this. I don't think you want me to, but the bottom line is to see somebody that knows what they're talking about. We've got several of these claims going on right now. Make sure that you recover the most money by talking to somebody that knows what they're doing and it has your back, and not only from the very beginning, but all the way through.
That makes a lot of sense. Scott, that's a great way to wrap up this episode on third-party claims. And again, I appreciate what you do. I appreciate the experience that you bring to the table. And you've been doing this for a long time, which means you've helped a lot of people and continue to help a lot of people. And I'm just glad to see the practice, it's one of those things. There's a lot on the table, and you don't want to leave benefits unused or unclaimed, and that's where someone like you know, comes into play here.
This is usually everybody only has one shot to get the amount they need, and this is not only for them but their family too. Other people depend on you, and you've got to take care of yourself to take care of your family. And the other part about this is generally myself and almost every attorney does this on a contingency fee basis. It doesn't usually result in a charge to come and see us. I don't charge for this. If you have a question about it, call me up. I like to talk. We can just hash out over the phone if there's a claim. But we're happy to talk with you on the phone. We're happy to meet with you in person. We're happy to discuss this through chat on emails. There's only so much information sometimes you can get from texting. But we'll try to communicate with you. And again, we don't charge you anything unless we recover for you. So there's no initial cost up front in this. I just can't emphasize how much, if you've had a third party claim, that you need to talk to somebody that knows what they're doing to make sure that you and your family are recovering the amount of money that you deserve in this.
And Scott, if somebody wanted to get in touch with you, what's the best phone number for them to use?
My office phone number is 502-937-5287. We also have a website, Scheynost Law, ScheynostLaw.com. You've got to be able to spell Scheynost to get that. We've got contact information. You can send me an email through that.
Yep. You've got a very active Facebook page as well.
We've got a Facebook page too.
So all of this is available, and I'll put that information in the show notes. So if you're listening to this podcast and there's a few paragraphs of information right below the actual recording, you'll be able to find all that contact information right there to make it nice and easy for you.
Perfect.
Scott, you'd mentioned contingency fee. Again, they don't have to pay. They don't have to pay unless there's a recovery, and that you take a percentage after that.
Right.
The Kentucky Bar Association requires us to make a statement that court costs and fees related to the case are actually the client's responsibility. How do you handle that? What does that really mean?
And of course, normally what we do is we forward those costs, which means as we're going through this, we pay for those costs. Doctor's reports, examinations, things like that. And then at the end of the case, what we do is we deduct our fee out, and then we deduct our cost. And we're reimbursed then. So for the most part, for most people, there's not only no fee, but there's no cost during the beginning of this, and we recover our fees and costs at the end. And in general, if somebody's been truthful to me, then we won't recover those costs at the end of this if they've lost their case. But we don't take many cases that we lose, and we don't usually have to worry about that. But if you've been truthful with me, then that money at the end of it, if we've incurred costs and for some reason it's not been successful, we're not going to recover that from you.
Wow, and that's generous, especially when you've been doing it this long. Like you said, you don't intend to lose very many of them, right?
That's correct, yes.
All right. Hey, Scott, I know you're busy. Thanks very much for your time. We look forward to getting you back here in the studio soon, and we'll take it from there. So, friends, thanks for your time as well, and I encourage you to check out ScheynostLaw.com. That's it for now. We'll talk to you soon. Bye-bye. Thanks for listening to this episode of Hurt at Work. Scott will be back in 2 weeks with a new episode. For more information, be sure to visit ScheynostLaw.com. That's SCHEYNOST law.com. You can also follow Scott's Workers' Comp office on Facebook. Until next time, be safe and remember, Scott's ready to help, especially when you and your family need it the most.